What you are witnessing is an absolute, unprecedented breakdown of courtroom decorum. No warnings, no delays, no final appeals. On the direct orders of Judge Marcus Caldwell, United States Marshals have just physically intervened in a federal courtroom, seizing documents, blocking exits, and effectively placing this high-stakes trial into a state of total paralysis. The defense team didn't just cross a line, they obliterated it. Following the explosive leak of the Witness 14 tapes, Judge Caldwell issued a scathing final ruling that sent shockwaves through the entire legal system. Immediate eviction, full-scale lockdown, and marshals positioning themselves between attorneys and the courtroom doors. This isn't just an interruption. This is judicial warfare. And the justice system just reached its breaking point. So what triggered this extraordinary intervention? 47 minutes before the marshals moved, a devastating leak surfaced online. Audio recordings from protected witness interviews that were never supposed to see the light of day. Recordings that directly implicated members of the defense team in coordinated witness tampering. This isn't just another procedural dispute. This is a federal judge declaring war on what he called a systematic assault on the integrity of these proceedings. And I have the timeline, the transcripts, and the footage right here. Let me show you exactly what they're trying to bury. But first, understand this. Judge Caldwell is a 23-year veteran of the federal bench. He's presided over organized crime trials, terrorism cases, and RICO prosecutions involving cartel kingpins. He doesn't flinch. He doesn't grandstand. Legal observers have described him as the calmest man in any courtroom until today. Multiple sources confirm that when Judge Caldwell viewed the contents of those leaked recordings, his expression changed visibly. A court reporter present described his jaw tightening, his hands gripping the bench. Then he issued the order that stopped everything. Marshals, secure this courtroom now. What was in those recordings that broke a 23-year judicial veteran? Here's what the Witness 14 recordings actually contain, the thing that everyone's talking about, the reason marshals are standing guard right now. This is the evidence. This is why you clicked. Witness 14, whose identity remains sealed under federal protection order, was a critical insider set to testify about financial fraud at the highest levels of the defendants' organization. According to court filings that emerged in the chaos, this witness had direct knowledge of falsified documents, hidden accounts, and coordinated efforts to obstruct federal investigators. The recordings capture 3 separate phone calls between Witness 14 and individuals the prosecution claims are directly connected to the defense team. In the first call, timestamped 11 days before trial, a male voice tells Witness 14, and I'm quoting directly from the transcript now released by the court, "You don't have to remember everything. Confusion helps everyone here. Just be confused." That alone would be damning, but it gets worse. The second call, 8 days later, escalates dramatically. The same voice returns, this time with specifics. "If you mention the March transfers, this becomes a different conversation for everyone, including your family's situation." Legal analysts reviewing this transcript have called it textbook witness intimidation with barely concealed threats. But the third call, the one that apparently made Judge Caldwell's hands shake, occurred just 72 hours before these proceedings began. In that recording, a different voice, female this time, delivers what prosecutors are calling the kill shot. The testimony package has been prepared for you. Study the summary document. Do not deviate from the prepared responses. Any improvisation, and we cannot guarantee your protection agreement, remains intact. They scripted the testimony. They threatened to revoke witness protection. They created a testimony package for a federally protected witness to memorize. According to sources within the prosecution team, audio forensics have now matched voice print patterns from these calls to phones registered to 2 associate attorneys working directly under the lead defense counsel. One source told Reuters that when this matching evidence was presented to Judge Caldwell in an emergency chambers meeting this morning, his response was immediate. This court will not be made complicit in the manufacturing of perjury. The leaked recordings also contain what analysts are describing as operational details, references to payments, references to future considerations, references to what happens to witnesses who go off script. Former federal prosecutor Daniel Harrington, who reviewed the publicly available portions of the transcripts, stated, "In 31 years of prosecuting federal cases, I have never seen evidence this explicit of defense-side witness tampering. This isn't a gray area. This is black-letter criminality captured on audio." The evidence package reportedly includes 14 separate audio files totaling over 6 hours of recorded conversations. Text message logs showing coordination between unknown numbers and defense team members. Financial records indicating payments routed through a shell company to witness 14's relatives. Internal memos discussing testimony management strategies. And here's the kicker that everyone missed in the initial chaos. The recordings weren't leaked by prosecutors. According to courthouse sources, they were leaked by someone inside the defense team itself. An internal fracture. Someone on the defense side decided to burn the entire operation down. Former Justice Department official Cassandra Webb told MSNBC, "When you see a leak originating from within the defense team, you're not looking at a mistake. You're looking at someone who decided that professional loyalty was less important than avoiding prison. That suggests the corruption goes even deeper than what's on these tapes." This wasn't a procedural error. This wasn't a miscommunication. This was organized criminal conduct by officers of the court. And now there's audio proof. Hit that subscribe button right now. This story is evolving by the minute, and I'm releasing follow-up coverage the moment new information drops. Subscribe so you're the first to see exactly how this legal earthquake unfolds. Now you've seen the evidence. But understanding how we got here makes this even more explosive. This trial, which legal observers had already called the most consequential white-collar prosecution of the decade, began 17 months ago with the indictment of corporate executives accused of orchestrating a multi-billion-dollar fraud scheme that devastated pension funds, wiped out retirement savings for thousands of workers, and allegedly involved bribes to regulatory officials. From the beginning, tensions ran extraordinarily high. The defense team, led by veteran trial attorney Harrison Mercer, employed what critics called scorched earth tactics, challenging every piece of evidence, filing motion after motion, and accusing prosecutors of political motivation at every turn. The prosecution, led by Assistant U.S. Attorney Patricia Delgado, maintained that the evidence trail was overwhelming and irrefutable. 3 months into proceedings, the first warning signs emerged. Judge Caldwell issued a rare formal admonition after defense attorneys were caught communicating with a sequestered jury member's family member at a public restaurant. The defense claimed coincidence. The judge called it troubling proximity to obstruction. 6 weeks later, a prosecution witness abruptly changed testimony mid-cross-examination, contradicting statements made under oath during depositions. When pressed, the witness appeared confused, disoriented, almost as if reciting from a script he hadn't fully memorized. The prosecution moved for a mistrial. Judge Caldwell denied it, but according to court observers, he began watching the defense table with increasing intensity. Then came witness 14. Witness 14 was scheduled to testify about the central allegations, the actual mechanism of the fraud, the identities of key decision makers, and the paper trail connecting executives to offshore accounts. This was, as one legal analyst put it, the ballgame witness. The night before witness 14's scheduled testimony, the recordings surfaced online, posted to an encrypted file-sharing site, and distributed through legal journalism networks within hours. By 6 a.m., every major news outlet had the audio. By 8 a.m., the prosecution had filed an emergency motion. By 9:15 a.m., Judge Caldwell convened an unscheduled chambers meeting. By 10:47 a.m., the Marshals were moving. According to sources present in the courtroom, when Judge Caldwell emerged from chambers, his face was set in what one reporter described as controlled fury. He didn't sit down. He stood at the bench, looked directly at the defense table, and said, "This court has tolerated aggressive advocacy. It will not tolerate criminality." Then he issued the termination order. Smash that like button if this is connecting the dots for you. Every like helps this reach more people who need to understand what actually happened in that courtroom. Not the sanitized version, but the real story. The bombshell moment came when the Marshals actually moved. According to multiple witnesses present in the courtroom, the sequence of events unfolded in less than 90 seconds, but felt like an eternity. Judge Caldwell finished speaking. The defense team sat frozen. Lead attorney Harrison Mercer began to rise from his chair, his mouth opening to object. Before a single word could emerge, 4 United States Marshals positioned around the courtroom perimeter stepped forward simultaneously. 2 moved directly toward the defense table. 1 blocked the main exit. 1 positioned himself beside the court reporter. The gallery erupted. Spectators gasped audibly. Several journalists later reported that they didn't initially understand what was happening. They thought there had been a threat, a security breach. Mercer's face went white. His associate counsel, Catherine Vance, physically stepped backward, her chair screeching against the floor. "Counselors," the lead marshal stated, "you are directed to remain in place. Do not approach the bench. Do not remove any documents. Do not communicate with anyone outside this courtroom." According to a reporter from the Washington Post who was present, Mercer finally found his voice. "Your Honor, you cannot—" Judge Caldwell cut him off with 2 words. "I can." The silence that followed lasted 11 seconds. Court transcripts confirm 11 full seconds of complete silence in a federal courtroom. That's when everyone realized this wasn't judicial theatrics. This wasn't a warning shot. This was the end. Don't go anywhere. We're not even close to finished. What happened next inside that locked courtroom is even more explosive. Drop a comment right now with your reaction. Did you ever think you'd see Marshals lock down a federal trial? This isn't the first time a federal courtroom has descended into chaos, but it may be the most dramatic. Think back to the 1970 Chicago 7 trial, when Judge Julius Hoffman ordered defendant Bobby Seale bound and gagged in the courtroom after repeated outbursts. That moment shocked the nation and became a symbol of judicial overreach. But here's the critical difference. In Chicago, the judge was accused of violating constitutional rights. In this case, Judge Caldwell is being praised by legal scholars for defending them. Then there was the 2007 case of attorney Mark Dreyer, who was arrested for impersonating other lawyers and defrauding clients of hundreds of millions. When evidence of his crimes emerged, his trial became a masterclass in courtroom damage control. But Dreyer acted alone. What's alleged here involves an entire defense team, a coordinated multi-person operation to suborn perjury and tamper with federal witnesses. The closest historical parallel, according to constitutional law professor Rebecca Thornton, is the Watergate prosecutions of the 1970s, when attorneys connected to President Nixon's re-election campaign were themselves prosecuted for obstruction of justice. What we're seeing today, Thornton told NPR, may actually exceed Watergate in its implications for legal ethics. These weren't campaign operatives. These were officers of the court sworn to uphold the justice system who allegedly weaponized that system against itself. The key distinction here is technological. In previous eras, witness tampering was alleged, suspected, sometimes proven through circumstantial evidence and testimony. This time, there are recordings, clear, time-stamped, voice print matched recordings. Professor Thornton emphasized the age of he said, she said in witness tampering cases may be ending. When you have audio, you have proof. And when the proof is this explicit, The system must respond with equivalent force. Judge Caldwell's response, many observers argue, was exactly that, equivalent force. Legal experts across the political spectrum are calling this unprecedented, not as hyperbole, but as technical description. Former federal prosecutor Daniel Harrington, now a legal analyst for CNN, told reporters, "I have watched defense attorneys push boundaries for 3 decades. I have never in my entire career seen a federal judge invoke marshals to physically contain a defense team during active proceedings." Judge Caldwell just wrote a new chapter in federal procedure, and every law school in America will be teaching it by next semester. Harrington added critical context that many observers missed. The key phrase in Judge Caldwell's order was, "preserve the integrity of evidence." That language signals he believes documents at the defense table right now in this courtroom may contain additional proof of criminal conduct. He sealed that room as a crime scene. Constitutional law scholar Rebecca Thornton, professor at Georgetown Law, emphasized the historic nature of the ruling. What Judge Caldwell has done is unprecedented, but almost certainly defensible. When officers of the court become active participants in witness tampering, the court has not only the authority, but the obligation to neutralize that threat immediately. He treated the defense table the way a judge would treat a defendant who pulled a weapon, as an active threat to the proceedings. Meanwhile, criminal defense attorney and former federal public defender Michael Okonkwo offered a more cautious assessment. Let's be clear, what's alleged here, if true, is indefensible criminal conduct. But we have to watch carefully how this unfolds. The rights of the accused don't disappear because their lawyers allegedly committed crimes. New counsel must be appointed. The defendant's constitutional protections must be maintained. Okonkwo noted, Judge Caldwell has walked a razor's edge here. If he executed this perfectly, it's a masterclass in judicial crisis management. If he made procedural errors in the heat of the moment, this could provide appeal grounds for years. Former Attorney General Eric Holder, commenting on social media, called the situation a dark day for the legal profession, but potentially a bright day for accountability. Legal ethics professor Sandra Chen told the Associated Press, "The message Judge Caldwell sent today will echo through every law firm in America. Aggressive advocacy is protected, criminal conspiracy is not. And if you cross that line, the court will not protect you. It will treat you as the threat you've become." Even voices typically critical of prosecutorial power have acknowledged the severity of what's alleged. If this analysis is valuable to you, smash that like button right now. It genuinely helps the algorithm push this content to more people who need to understand what's happening. One click makes a real difference. So what does this actually mean going forward? First, the immediate legal consequences are staggering. Judge Caldwell's order effectively declares a mistrial, but not the kind that benefits the defense. The defendant remains in custody. The charges remain active. But now the defense team itself is facing criminal referral to the Justice Department's Office of Professional Responsibility and potentially the FBI's Public Corruption Unit. Multiple legal analysts have confirmed that the attorneys involved could face charges including obstruction of justice, witness tampering, subornation of perjury, and conspiracy. If convicted on all counts, we're talking about potential sentences exceeding 15 years in federal prison. For the defendant, this creates an extraordinary legal paradox. The person ostensibly being defended now needs to prove they had no knowledge of their own attorney's criminal conduct. If that fails, charges of conspiracy to obstruct justice could attach to the defendant as well, turning what was already a serious prosecution into something potentially life-destroying. Second, the systemic implications cannot be overstated. Every pending federal case involving this defense team, and there are 17 active matters according to court records, will now face immediate review. Motions for new trials, appeals based on ineffective assistance of counsel, and civil liability claims are already being drafted, according to sources within the federal court system. The law firm itself, Morrison & Mercer LLP, faces potential disbarment proceedings against multiple partners. Their malpractice insurance exposure could reach 9 figures. Third, the long-term implications for defense practice are seismic. Legal ethics professor Sandra Chen explained, every interaction between defense attorneys and witnesses will now face heightened scrutiny. Every phone call, every meeting, every communication. Judge Caldwell has established that when evidence of tampering emerges, courts will not hesitate to invoke extraordinary measures. That changes the calculation for every defense attorney in America. The implications for witness protection programs are equally profound. Witnesses in federal cases will now face a terrifying reality. The attorneys for the person you're testifying against might actively work to compromise you, threaten you, script your testimony against your will. This could chill witness cooperation across the federal system. If I'm a potential witness, former prosecutor Harrington noted, and I just watched what happened to witness 14, approached, threatened, manipulated by officers of the court, why would I ever trust the system to protect me? Finally, the precedent Judge Caldwell has established will reverberate for decades. The message is clear. The courtroom is not a zone of immunity. Attorneys who weaponize their access, their privilege, their position of trust will face consequences not just from bar associations, but from marshals, from prosecutors, from the full weight of federal criminal justice. This isn't an abstract principle anymore. It's live, it's recorded, and it's playing out in real time. And then the defense made it even worse. Within 2 hours of the courtroom lockdown, Harrison Mercer's personal attorney released a statement that legal observers are calling catastrophically ill-advised. The statement read in part, the unprecedented actions taken today by Judge Caldwell represent the most dangerous assault on attorney-client privilege in modern American history. My client and his associates categorically deny any wrongdoing and will pursue all available legal remedies against those responsible for this judicial overreach. Instead of expressing concern about the evidence, instead of announcing an internal investigation, instead of distancing the firm from the conduct allegedly captured on tape, Mercer's team attacked the judge. Former federal prosecutor Harrington responded bluntly, that statement is Exhibit A for why lawyers sometimes need lawyers who understand when to stop talking. Attacking a federal judge hours after audio evidence emerged of your team tampering with witnesses? That's not a legal strategy. That's professional suicide. The statement went further, claiming the leaked recordings were illegally obtained and therefore inadmissible and irrelevant. Legal experts immediately noted the flaw. The recordings weren't obtained by prosecutors through illegal means. They were leaked, apparently from within the defense team itself. The Fourth Amendment protections against illegal search don't apply when your own colleague decides to expose you. By 6 p.m., 3 junior associates at Morrison & Mercer had resigned, according to sources within the firm. 2 of them retained personal criminal defense counsel before making any public statement. Mercer himself has not appeared publicly since the lockdown. Sources indicate he remains under what's described as soft detention, not formally arrested, but not free to leave the courthouse either, pending a determination of whether he presents a flight risk. His co-counsel, Catherine Vance, reportedly broke down during questioning, according to sources familiar with the proceedings. Her attorney later stated she is cooperating fully with investigators. Here's the problem with the defense's response. When your defense is attacking the judge rather than addressing the evidence, you've already lost the argument. The recordings exist. The voice prints match. The witness tampering is documented. No amount of privilege claims can erase audio evidence of criminal conspiracy. And Mercer's aggressive denials may have just guaranteed that prosecutors seek the maximum possible charges. But beyond the immediate legal fallout, this is really about something much larger. This is about whether the justice system can police itself. For years, decades, Americans have watched cases where the powerful seemed exempt from consequences, where money bought the best lawyers, and the best lawyers found ways to manipulate, delay, obstruct, where ordinary people faced the full weight of the law while those with resources danced around it. What happened in that courtroom today represents something different. A federal judge, a 23-year veteran with nothing to prove and nothing to fear, looked at officers of the court who had allegedly betrayed every oath they took and said, no more. Not quietly, not through bureaucratic channels, not with a strongly worded letter, with marshals, with handcuffs ready, with every exit sealed. This affects every American, regardless of political affiliation. Because if those charged with defending the Constitution can be held accountable when they violate it, perhaps there's hope that the system still works. Perhaps there's hope that justice isn't just a word. The question now is whether this moment marks a turning point or just an exception that proves the rule. Subscribe right now if you want to see how this unfolds. This story is moving at unprecedented speed, and I'm covering every development. Hit that subscribe button and the notification bell so you never miss an update. Here's where things stand right now. The courtroom remains sealed under Marshals supervision. According to federal court officials, no determination has been made regarding when or whether proceedings will resume. Lead defense attorney Harrison Mercer is under what sources describe as investigative detention. Technically not arrested, but confined to a secure location within the federal courthouse pending judicial review of flight risk. Co-counsel Catherine Vance has been released after agreeing to surrender her passport and submit to electronic monitoring. Sources indicate she is actively cooperating with investigators. The firm of Morrison & Mercer, LLP, has canceled all court appearances across 17 pending cases, citing internal emergency review. 3 partners have reportedly retained personal criminal counsel. Witness 14 has been moved to an undisclosed location under enhanced protective custody. Federal marshals have assigned a dedicated detail, and the witness's previous location has been classified under seal. The Justice Department's Office of Professional Responsibility has opened a formal investigation, which sources indicate will be fast-tracked given the public nature of the evidence. Most critically, Judge Caldwell has scheduled an emergency hearing for tomorrow at 9 a.m., at which he will determine whether criminal referrals will proceed immediately to a grand jury, whether the defendant will be assigned new counsel or offered a continuance, whether additional attorneys at the firm face sanctions or arrest. Legal observers expect additional shoes to drop. The question of who leaked the recordings from within the defense team remains unanswered and may prove central to everything that happens next. Keep a close eye on that 9 a.m. hearing. Every legal expert I've spoken to believes tomorrow morning will determine whether this becomes a legal footnote or the defining prosecutorial moment of the decade. The stakes have never been higher. The evidence has never been more damning. The system has never responded with such visible, immediate force. What happens tomorrow, what happens in the weeks and months ahead, will determine whether this moment marks genuine accountability or another chapter in the long story of justice delayed. This isn't just another scandal. This is the justice system confronting its own failure in real time, on the record, with marshals at the door. If you want to understand what happens next, if you refuse to accept the sanitized version, subscribe and hit that notification bell. I'll be here covering every development, every revelation, every consequence. I'll see you in the next one.